Hi, thank you for having me. My name is Christy Ibram. I'm an attorney at a law firm called Jones and Ibram, and we focus on the needs of people with developmental and intellectual disabilities and their families. So I primarily do a lot of guardianship and also a lot of special needs trusts and wills for families who have somebody in their family with special needs. So I have a PowerPoint that I'm going to use, and I'm going to go ahead and try to share that screen now. And hopefully you guys can see that. Now, if you have questions as we go, feel free to put them in the chat box, and after every few slides, I will stop and see if there are questions there, although I don't think I can see them as I go, so I may have to switch back and forth a little bit, or maybe one of the hosts can tell me if there's starting to be a lot of questions in the chat box, and we'll also have some time for questions at the end. So thanks for being here tonight. I know it's a beautiful evening, and I'm grateful that you're here. I know it's been a difficult year for everyone. As I talk to my clients, I keep hearing again and again the impacts that COVID is having on people with disabilities and their families. A lot of people with disabilities not being able to do their supported work jobs, or not being able to do their day programs, not being able to do their social activities, being stuck at home too much. And I know it's been a really difficult year. And so hopefully tonight we can just enjoy a little bit of time together learning about a few things that might be helpful for things in the future for your family. So primarily I'm going to talk about guardianship and special needs trusts. And I'm going to go ahead and start out by talking about guardianships. So why might a guardianship be necessary? Well, when people turn 18, it's kind of a magic legal age where all of a sudden they can do a lot of things that they couldn't do the day before. Like all of a sudden you're old enough to vote or to sign a contract, to get married, to make all your own medical decisions, to make all your own housing and educational decisions. And so if there's someone who needs assistance and isn't able to make all those decisions on their own, then a guardianship is one option. Now, I grew up with a brother with Down syndrome who has since passed away, but I remember when my parents got guardianship for him. He was a couple years older than I was, so I was a teenager when this was going on. I remember my parents being really surprised that they needed to go through a court process to be able to continue to be his guardian. Because when you're the guardian of a child who's a minor, obviously you just have full authority to do things for someone, but once your child turns 18, you don't have that legal authority anymore. And because the law presumes that people have the capability to make their own decisions unless proven otherwise, that's why there has to be a court process to be able to continue that authority past someone's 18th birthday. We always try to see if there's some other alternative to guardianship that will work instead. And that's because a guardianship does take rights away from a person. It's also expensive. You have to go through a court process. It's kind of a hassle, not the most pleasant process in the world. And so if there's something that will work instead, we always try to do that first. So some of those options might be a power of attorney, a limited guardianship, or maybe just using a trust instead. So I'm going to talk about each of these alternatives, and you can think about how this might apply to your particular situation. So a power of attorney is just a document that once someone is 18 years old, they can sign that gives somebody else authority to help them make decisions. So it's less restrictive than a guardianship because it doesn't take away someone's rights. It just adds somebody to help them be a decision maker. So this is less expensive, it's much more straightforward, and so you might think, well, why wouldn't everyone just do that then? Sometimes it won't work, and that's for a couple of reasons. One is the person with the disability has to have capacity to sign the document, and capacity is a legal term that just kind of means having enough understanding to be able to understand what that document is, and if they sign it, what it means. And so for some people with disabilities, that's a standard that they can't meet because they're perhaps not able to understand the document to that level. And in that case, power of attorney is not an appropriate option because it needs to be something that someone is consenting to fully. Powers of attorney are revocable, meaning if someone signs one, they can be undone at any time by just being torn up and thrown away. And this is a good thing in the sense that it makes it flexible, but it also can be a bad thing if you're worried that someone with a disability might be vulnerable to someone else having them sign a power of attorney. If someone is kind of vulnerable to being talked into that kind of thing, then perhaps a power of attorney is not going to give the protection that the person needs. Kind of similarly, if the person with the disability has poor judgment in some way and you're concerned about that, then sometimes a power of attorney won't work because a power of attorney really allows someone to still make their own decisions. It just allows somebody to help them, to work with them, but they are still the final decision maker. And sometimes that won't work well. So, for example, if someone really needs a dental procedure and they wouldn't want to consent to it because they knew that it was going to hurt to get a cavity filled or something like that, or I had a family where their son with a disability had a power of attorney naming his parents, and he needed a shoulder surgery. He had a torn rotator cuff and went in for the surgery. Everybody was all ready to go, and then he changed his mind and didn't want to do it. If they had been his guardian, they could have asked the surgery to go forward, but since they only had power of attorney, they weren't able to do that. So sometimes kind of sorting out, is your family member someone who would have good judgment in those kind of situations and do things they needed to do for their health and also for their financial well-being? Or is it someone whose judgment really needs additional help and needs someone to be able to make decisions for them, kind of like you do for a child who's a minor? So these are all kinds of things to sort out to decide whether a power of attorney or a guardianship is appropriate. And sometimes it's very clear which is the appropriate way to go. And sometimes it's a little bit more of a gray area where either could perhaps be appropriate. And we always really do try to do what's the least restrictive option that will make sense for everyone. So kind of comparing a guardianship and a power of attorney. Guardianships require that you go through a court, and powers of attorney don't. A guardianship doesn't necessarily require that the person understands the process, but a power of attorney does. A guardianship, once it's set up, has to be dismissed by a court, whereas a power of attorney can just be revoked. Guardianships are more expensive, and guardianships allow bad decisions, so-called bad decisions, to be replaced, whereas a power of attorney wouldn't. Power of attorney really allows you to, if you have a power of attorney for healthcare, to access someone's medical records, talk to their doctors, help them with decision making, but not to be that final decision maker. Okay. Sometimes a special needs trust or an ABLE account can be an alternative to a guardianship if the person really only needs help managing money. So perhaps someone really is capable of making their day-to-day decisions but doesn't really understand how to manage money. Sometimes a special needs trust could help in that way. But a trust really is only for money, and so it's not going to help with other matters such as health or housing or education. Okay. So guardianships have two parts, the guardianship of the person and the guardianship of the estate. And I want to say here that starting next January in 2022, our law in Washington State for guardianship is going to change. And what's now known as the guardianship of the person, which covers medical and health and education, pretty much everything except for money, is going to be called guardianship. And then the guardianship of the estate, which is the money, is going to be called conservatorship. So these terms are going to change a little bit, but for right now, they're called guardianship of the person and guardianship of the estate. So one thing we always try to sort out is if the person needs a guardianship, do they need both of these parts, or are they able to manage one of these parts on their own? And also each part can be a full guardianship, meaning the guardian has full control of all decisions for that part, or it can be limited. meaning that the guardian just has a few powers over a few particular things, or that the person has retained rights over some particular things. So for example, perhaps someone can't really manage all their own money, but they could manage $200 on a debit card. We could do a limited guardianship of the estate and ask that the person be able to control some of their own funds. Or perhaps someone can really make their own social and some of their own medical decisions, but they need help signing contracts and interacting with insurance companies and so on. These things can all be specified in the court order that appoints the guardian. And so that court order really can be tailored to whatever the person needs and is designed to have as few restrictions as possible. I've had a couple of situations where the person with the disability is okay with the guardianship except for a couple of things that are important to them that they want to be able to do. And so often we're able to keep those things, we're able to write them into the court order so that someone can keep those rights that are important to them.
En eso.
Okay. Why don't we stop there and see if there are any questions? I can't see the chat, but I bet I can if I stop sharing. So why don't I go back and forth a little bit? So I'm going to stop share. Let's see if I can see the chat. Okay, looks like there aren't really any questions yet. Does anybody have any that they want to put in at this point before we keep going talking about guardianship? Where does supported decision-making fit into these? Thank you. So this new term, supported decision-making, is going to be starting in the law, and my understanding is that also kicks in next January, starting in 2022, and that will be an option. That's an alternative to guardianship, a less restrictive option where someone can have, instead of a guardian or instead of a power of attorney, someone who is a supported decision maker, either in general or for a particular event or process or thing. Okay, if you have other questions, go ahead and type them in there. I'm going to go ahead and go back to the presentation, and then I'll switch back and forth periodically. Okay, so once a guardian is set up, then the guardian has ongoing responsibilities. So it's not just kind of a one-time thing. So once a guardianship is set up, the guardian has to do reports to the court on an ongoing basis. And usually this will be after 1 year, and then every 3 years, just continuing on into the future. And these reports can be kind of stressful for families, especially because there's a section in them where you have to do an accounting process, where you show what income has come in for the person with the disability and what has been spent, and it all has to match. And you can imagine, especially if it's been 3 years since your last court report, going back and trying to reconstruct that can be really difficult. So it's important as a guardian to set up some kind of process to make it easy for yourself to track those funds. And so some ways to do that would be just to keep an Excel sheet or even a spiral notebook, or to keep everything on one debit card so that you have clear statements that are easy to track. Some kind of system like that that will make it easy for you on an ongoing basis. Also, an ongoing responsibility of the guardian is to make decisions on behalf of the person with the disability. And so sometimes I talk to families about the future, because parents are often worried, you know, what will happen when they are not able to serve as guardian anymore, and who could they ask to do this job instead. Sometimes there's a sibling that the family or that the parents are not sure about, kind of requiring that responsibility for the sibling. But sometimes it helps to think of a guardian really as a decision maker. It doesn't mean that the person has to live with the person with the disability or provide their daily care. It just means that they are doing decision making for them. And so sometimes when you look at it that way, that changes perspective a little bit as to who might be a good person to help in those kind of situations. Okay, timeline. I've always said before that we prefer to start a guardianship, if we can, about 6 months before the person turns 18, but that we can start after that. And I've done guardianships for people who are 40 or 50 or whatever, so it doesn't have to be done around 18. The nice thing about doing it around 18 is that when the person turns 18, it's all in place. And if you're working with a facility like Children's Hospital, where they're very particular about guardianship paperwork, then that's a good thing to do. The law just changed this year. I mentioned that it's going to change next year as well, but part of it phased in this year for minors with a slightly different kind of guardianship. And since there's this new minor guardianship law, we've now found, at least in King County, that the judges prefer that we wait until the person with the disability turns 18 before we file for guardianship. So that's our current procedure, and that may change over time, but that's what we're doing right now. And the standard timeline to get it set up is 2 to 3 months from start to finish if there's nothing contested. And by contested, I mean perhaps there's divorced parents who both want to be the guardian, or perhaps the person with the disability doesn't want a guardian and asks for their own lawyer. Something like that can make it stretch out longer. But in most situations, it's about 2 to 3 months start to finish. Other things that I get frequently asked, one is, what is a standby guardian? So a standby guardian is a backup person that can make decisions if you as the guardian are not available. Starting next year with the new law, they're not going to have standby guardians. But if you are doing a guardianship this year, you would need to figure out who your standby guardian was going to be. This can be stressful for families because sometimes there isn't anyone obvious that makes a good choice for a standby guardian. And sometimes in that kind of situation, you can select a professional guardianship agency. There are professional guardianship agencies, there's many in our area and across Washington state, who are willing to serve as executors for people, as guardians for people, as trustees for people. And so if you don't have someone in your family that can do those things, a professional can be a good choice. Sometimes people ask, should I have a co-guardian? And co-guardians can be a great option. Often two parents, even if they're divorced, can work together and be co-guardians. That actually makes a lot of sense if the person with the disability is spending time with both parents, because that way both parents have legal authority to do what needs to be done. Sometimes divorced parents don't work well together, and so then that model doesn't work well, and someone needs to be the main guardian and someone can be the standby. You can also have a co-guardian, a parent and a sibling, or a parent and a longtime family friend, something like that. The advantage to having co-guardians is that if something happens to one guardian, the other person is already in place and has that needed legal authority. So sometimes that can be a good thing. And so when people come in to talk to me about guardianship, we sort through those options. We figure out, should we do a guardianship or a power of attorney? If we're going to do a guardianship, should we have a co-guardian or just a sole guardian? And who should the standby guardian be? And what's the right timeline and how do we approach this? And then we talk about the particular forms and procedures that have to be filled out and that kind of thing. So that's kind of what we're looking at when we launch into doing a guardianship. All right, I think I'm going to unshare again to see if there are any questions in the chat box, and then we will transition to talking a little bit about trusts. Okay, looks like.
Christy, I'm happy to help monitor or pass along those questions if that is useful to you.
Okay, thanks. Yeah, that would be great. I can see these now, but after I transfer back over, that would be great if you want to do that for me. Okay.
Perfect.
So does it mean that supported decision maker is not available now? The supported decision maker set up by a lawyer or a guardianship. That's my understanding, is that that starts next January and isn't officially set up to be ready to roll in our state yet. Okay, what options are there if we don't have someone to support our kids as guardians after we pass? So a professional guardian can be a good option for that. I think that's the main thing people do if there's not anyone else that they want to name as a standby guardian. Okay, if in agreement, can both divorced parents be the guardian? Yes. Or can only one guardian be chosen? No, there can be two. Will current standby guardians lose their status in 2022? I don't know the answer to that. I've got a meeting with a couple of the judges that are meeting with a bunch of the guardianship attorneys online this week, and we were able to submit questions, and that was one thing that I asked was, when the new law starts, what happens to standby guardians? My understanding is there aren't going to be any, so I would think that standby guardians would lose their status. That would be my guess, but I don't know yet. What is the average cost? That varies a lot depending on the situation in the county and which law firm you're using. How do we start the process since our daughter will be 18 in July? You can contact an attorney that works in your county. I would be happy to work with you if you're in one of the counties that I work in, which are a lot of the counties in Western Washington. And the way that you do that would be to contact an attorney and have a consultation about your particular situation. So yes, feel free to contact me. I would like to do that. And if your daughter is turning 18 in July, then that timing would be really good. There are people who do guardianship on their own. The forms are available online. And so sometimes people are able to make that work. It just does have a lot of steps of paperwork, and it's not the most intuitive system. So a lot of times people will call me and say they've started their guardianship on their own and now they need some help. So that's an option as well. Some counties like Snohomish and Skagit have a guardianship facilitator who can help people a little bit with their forms and so forth, so that can be useful as well. Okay, let's see. What options do low-income families have to cover attorney costs? So in some counties, there are these guardianship facilitators. There are, if you go to Washington court forms, there are forms online, and so you can try to make that happen. That's probably the best low-income option, is just to try to file it on your own. As far as Northwest Justice Project and some of those organizations, I'm not aware of anyone that's doing guardianships at this point. We are split between Oregon and Washington. Are the two states vastly different RE guardianship law? Yes, they are quite different. So I would think you would want to think about the residence of the person with the disability, whether they really reside in Washington or in Oregon, to determine which kind of process you want to do. How do we contact you directly? Here, I will put my contact information is also on my PowerPoint if you guys have access to that. Here's my email address. And here's my phone number.
And so everyone, if you haven't received the materials for tonight's presentation, it was sent out this evening and I believe yesterday as well. So check your junk mail, because sometimes our email has a tendency of ending up there. And then if you didn't receive that, please reach out to myself, emily@gowise.org, or Beth, and I'll put both of our emails in the chat as well.
All right, will this training cover yearly reporting? I'm not going to get into the details of yearly reporting in this particular presentation, just because I don't have a lot of time. But generally speaking, there are forms available online for if the person with the disability has under $80,000 or if they have over $80,000. So that's kind of how the court splits it out. And so filling out that report form and then having an order that goes with it for the judge to sign, those are the two most important documents that you'll be submitting when you're doing a yearly report. If you're on a yearly report and the person with the disability doesn't have a lot of assets, you can also submit an order asking that the court put you on a 3-year schedule. So that can make your life simpler, so that it only rolls around once every 3 years instead of every year. Okay, I'm going to go back to my presentation. Okay, and if you have more guardianship questions, then maybe Emily can keep an eye on those for me, but otherwise I'm going to talk a little bit about wills, special needs trusts. And I'm just going to just barely mention able accounts, since that's what the second half of the presentation is about tonight. I feel like he's going to cover that in a lot of detail. Okay, so why have a will? A will is an important document that gives instructions for after you pass away. And if you have a will, it allows you to select your executor, which is the person who does all the paperwork for you with the courts after you pass away and make sure that all of your things get given to the people that you have designated and so forth. If you have a will, it also allows you to establish what are called testamentary trusts. And a testamentary trust just means a trust that is in a will. And there's a number of kinds of those that you might have. You might have a trust to help minimize your exposure to Washington state estate tax. You might have a trust for your kids who are minors. You might have what's called a special needs trust for somebody with a disability in your family. We're going to talk more about those in particular. But there's several kinds of trusts that can be tucked into your will. Another reason to have a will is that it allows you to control what happens to your probate assets after you pass away. So this can be really important. For example, if you're not married to your partner, perhaps you have a long-term relationship, but you're not married, but you would want to leave assets to that person, for example. Or if you have stepchildren that you haven't adopted, but you would like for them to have a share of your estate. Things like that are important to have a will to specify those things. Or perhaps you have 3 children and one has a disability and you'd really like that child to have a greater share of your estate than your other children, perhaps. So it allows you to specify all these things. And it also allows you to have a plan that you can share with your family. And also after you pass away, it makes things a lot simpler for your surviving family, because through your will, they know what you wanted to have happen to your things. So what's a trust and what's a special needs trust? A trust is kind of like a bubble around some assets to protect them. And there's some terms that go with it, like trustee. The trustee is the person who manages the trust and is responsible for the money in it. The beneficiary is the one who gets the benefit of the asset. So for example, with a special needs trust, with my brother, for example, if there was a special needs trust for my brother, he would be the beneficiary. That means the money needs to be spent on him that's in the trust. And the trustee perhaps could have been my parents or could have been me, whoever it is managing the money, that's the trustee. And what a special needs trust does is it allows somebody to stay on benefits like SSI or DDA benefits or Medicaid. So a lot of these programs only allow someone to have $2,000 in their own name, the person with the disability. So you can imagine if someone suddenly inherits some money from someone, not in a trust, that they might lose those benefits. And a special needs trust, if it's set up properly in advance, prevents that from happening. It allows the person to stay on their benefits and those benefits not to be interrupted, and for the person with the disability to get the benefit of those funds. Okay, this is perhaps this next little couple of slides, perhaps the most complicated part. So hopefully I can explain it well, but let me know if you have questions. There are a couple of main types of special needs trusts, and they are divided often into first party, sometimes also called self-settled, or third party. So first party trusts are for someone with the disability's own money. So going back to the example of my brother, let's say my brother was working and making money and having a hard time staying under that $2,000 limit. Well, we could set up what's called a first party trust for him to put those extra wages that he has into so that he can save. Because really otherwise he can't ever save more than $2,000. So if he wants to go on a big trip, or if he wants to buy a power wheelchair, or if he wants to really buy anything that costs more than $2,000, if he wants to save towards a condo, anything like that, a trust is a good vehicle for him to be able to save. Third-party trusts are for anyone else's money. So if I wanted to set up a trust for my brother, if anyone else wanted to, a third-party trust would be for anyone else's money that wants to set something aside. So the type of trust that you would have in your will would be a third-party trust, because it's not for the person with disability's own money. It's for your money that you are setting aside for that person. Okay, so let's talk about first party. This is for the person with the disability's own money. And you might say, well, how would the person with the disability have more than $2,000? Well, like I said, they could be earning wages. They could inherit money that wasn't put in a special needs trust. So for example, grandma leaves the person with the disability and all her grandkids. She just says in her will, I leave each of my grandchildren $10,000. Okay, she doesn't put it in a special needs trust. Well, that's more than $2,000. So that is going to be a problem if this person is on SSI, Medicaid, DDA. And so that money from grandma can be put in this kind of trust, first party. It has to be first party because it came directly to that person. She just left it directly to him, okay? Sometimes you apply for benefits like SSI and you get denied and then you appeal. And
Y a veces
I can hear the, okay. You can, sometimes it will take a year and a half or something to get your benefits. And so then once you finally get them, you get this big back payment check. And so sometimes they give you 9 months to spend that down. So you can either spend it down or you could put it in this type of a trust. Sometimes you might just get, somebody with a disability might get a gift from a relative, not through a will, but just a gift. Sometimes they might get a settlement. I just had a case where someone with a disability was a passenger in a car accident and received about $15,000. So that, you know, was going to mess up her benefits if we didn't get it put into one of these first party special needs trusts. So these trusts are great, but they have a couple of disadvantages. One is that when the person with the disability dies, if they've received Medicaid services throughout their life, then Medicaid has a lien when that person dies and can be paid back for those funds. So if the person has $10,000 and they pass away, the state Medicaid agency has a tally of what Medicaid has been spent on each person in our state. And so they will submit a lien and often it will wipe out that trust. These types of trusts often also require that they be supervised by a court. Okay. So let's talk about third-party special needs trusts. So if you remember, third party is for anyone else's money except for the person's own money. So anyone else could put money in a third-party special needs trust. And there's a couple of ways to set these up. One way is you set it up to exist while you're alive. So if my brother were still alive right now, I could say, I think I would like to set up a trust for him and I would like to put $100 a month in there just so that he has some extra supplemental money, and I want to just go ahead and do that now. Or alternatively, I could say, well, I'm not going to do that now, but in my will, I'm going to say that when I pass away, there's going to be a trust tucked into my will that's going to leave him part of my estate. And so lots of times I like to work with families to decide which of those things make sense. So setting up a trust now can be great because it exists right now. Other people can contribute to it. You know, I could put money in there. My parents could put money in there, anyone who wanted to. But a lot of times there isn't really a reason for it to be there right now because once a trust is set up, it's hard to modify. You have to file tax returns on it every year. So maybe it's better just to tuck it in your will and just have it be created after you pass away. So there's kind of some pros and cons there, and we talk through those and figure out what might make sense for your particular family. Okay, so why is it good to plan in advance? Because if you have a will, you could set up a third-party special needs trust, and that means when you pass away, the assets that you're leaving to that person with the disability go into that trust, and their benefits don't get messed up. Medicaid doesn't have to be paid back. But if you haven't done that kind of planning and you pass away and if your family member with the disability inherits money from you, It can mess up their benefits. They can lose their benefits. And after that, we could set up a first party special needs trust for them. But then after they pass away, Medicaid has to be paid back. A court usually has to supervise it. Your family members that are surviving have to figure out how to get that set up so the person doesn't lose their benefits. And sometimes people don't even know that's an option. So I've had people come into me and say, oh, well, my parents passed away without a will, and so my sister or my brother lost their benefits because they had more than $2,000 because the sibling didn't really know that it was an option to even set up a first party special needs trust. So it just makes everything a lot smoother and cleaner if you get that planned for in advance. Okay, I'm going to do one more slide and then I'll see if there's any questions. The DD Endowment Fund Trust, some of you may have heard of. It's also known as the DD Life Opportunities Trust, or sometimes called DD LOT. So somebody has to be a client of DDA, the Developmental Disabilities Administration, to be able to have a trust with this trust. And what it is called a pooled trust, meaning that there's one trust document, and then there's lots and lots of people that have accounts there. I think they have about 2,500 trusts there now. And they have both first party and third party trusts available. So this is a way that if you're thinking to yourself that you can't really think after you are gone, who would manage money for the person with a disability in your family, this can be a great option because the Arc of Washington is the manager of this trust and they do a really nice job. So this is a way that you could get something set up and then designate it in your will. Or it's also something if the person with the disability is working and has those extra funds that they could put money in this type of trust. So sometimes it can be a really good option for people. Okay, Emily, are you able to tell me if there's any questions right now?
Yeah, so there were a couple that came through. The first one was, can I just open up a savings account in my name and avoid having a trust?
So you can have a savings account in your own name, but you can't put someone else's money in there. So for example, if you have a son or daughter that is an adult and is working, you can't put their money into your account. It's their money. So that's why a trust can be a good option, is for their money. Now, as far as your own money, yeah, it makes just perfect sense to just keep an account in your own name that you kind of know in your own head is for that child with a disability rather than setting it up into a trust. That can be an okay thing to do. Sure.
Great. The next question is, can a person with a disability pay their parents' rent, which could then be placed in a third-person trust in order to avoid the Medicaid payback situation with a first-person trust?
Yes, that is a good thing to do. So lots of you may have heard about this. So if somebody with a disability is, say you have a child with a disability who's an adult and is getting SSI, they can pay you room and board. And that room and board comes to you kind of like a landlord if you own the house that they are living in with you. And then you are welcome to put that in a third-party special needs trust if you want, or to spend it on them in a different way, or to just spend it yourself. It becomes your money at that point. So that would work.
Those are the only questions right now.
Okay.
If other people have them, feel free to put them in the chat and we'll keep monitoring them. And thanks so much.
Okay, thanks, Emily. Okay, ABLE accounts. Let me just say that your next speaker, Peter, is super knowledgeable about ABLE accounts, and so he is going to cover those, but they are another nice option, especially for if there's somebody with a disability who's running up against that $2,000 limit all the time and needs a place to be able to save their extra funds. Okay, can I do my trust and estate plan myself? If you have the wrong type of trust, or if you have a will that isn't legally witnessed according to Washington state rules, or if you have no will, it really can cause problems for the person with the disability's benefits. So I think it is important to have an attorney do your estate plan and have it be someone who's done special needs trust before and understands the different types. Okay. So just to kind of summarize, it's important to have a will for the reasons that we talked about earlier. It's important to have a third-party special needs trust either in your will or separately that works in combination with your will. And by that, I mean that perhaps you choose to have a separate special needs trust, a third-party one. Then your will needs to say that the share that you're leaving that family member goes to that trust. Otherwise, it's not just going to find its way there. So that's what I mean about working in combination with your will. You also want to make sure that your beneficiary designations, like on your life insurance, name the trust rather than the individual if you're wanting that money to get to the trust. So if you, for example, have a special needs trust for your child, but your life insurance beneficiary just names your child, not the trust, then it's not going to find its way there to the trust and it can still mess up their benefits. So that's something that you want to be careful of, are those things that have a beneficiary designation. Now, if you don't have a special needs trust and you don't have a will yet, then you don't want to name a trust that doesn't exist. So it's important on those beneficiary designations forms, which usually will have with life insurance, sometimes with IRAs or 401ks. You want to make sure that those say the right thing. I think it's good once you have your estate plan just to review it every 5 to 7 years. I often sit down with people who have done an estate plan years previously, and sometimes we walk through it and it still looks quite good and it doesn't need a lot of changes. Other times I say, okay, now you've named so-and-so as your backup executor. Is that still who you would want? And people say, what? That's who we chose? So it's just good to take a look at it every once in a while, make sure it still says what you want it to. Another important thing is to have a power of attorney for yourself in case something happens to you. For example, if you're in an accident or you get dementia, you have a stroke, and you're not able to make your own decisions, if you have a power of attorney document that designates someone to make decisions for you, then that would avoid you having to have a guardian at some point. A healthcare directive or an advance directive is something that you can have that specifies that you don't want to live on life support if you don't want to. A lot of people feel strongly that they don't want to live on a machine. And so having a directive can help with that. And often you can get those free at your doctor's office. Okay, so just to summarize, our law firm has worked with hundreds of clients over the years on these kinds of issues. These are the things that are kind of right up our alley. And we try to keep the process really straightforward and efficient. And all of our attorneys and staff have somebody with a developmental or intellectual disability or a mental health issue right in their immediate family. So we feel like we're able to have that in common with our clients. All right, so that's the end of my presentation, and I think I'm just about right on time. So I think we have 5 or 10 minutes for questions. Is that right, Emily?
Correct. And someone's asking, do you support clients in Southwest Washington?
So especially now during COVID, we've found that we can do a lot of work on the phone and on Zoom, especially for estate planning. We can do estate planning pretty much anywhere. But as far as guardianship, our firm practices in King, Snohomish, Skagit Island, Pierce, Kitsap. I may be forgetting one. I think that's all.
And someone's asking where to find your contact information. So we put it in the chat, and then we also, me, Emily, and Beth, we're sending the information out for the materials tonight. So Christy's information is located in the materials that if you have not received it yet, double check your email and then follow up with us, and we're happy to get that to you.
Okay. Someone's saying, would a court hearing be in person now or on Zoom? The only court that I know of that's open right now out of those 7 that I just mentioned is Island County. They haven't had much virus up there. They've been fortunate. All the rest of them are on Zoom or just on what's called court call, where you just call on the telephone. And so that's been a nice option for people. Clark County, I have not been doing guardianships in Clark County just because that is a few hours from my office, which is in Redmond. So, but I do know I have some good referrals for Clark County. If you would like to email me, I would be happy to send those to you. I don't remember their names off the top of my head because I don't know them personally.
Yeah, and if you want to share that with us, Christy, we're happy to email that out to the group as well. We can email that to everyone. And then I know Peace, who is on the line tonight, is a great resource for other law firms and people that are practicing and doing guardianship in Clark County.
Okay, excellent. If the disabled adult will qualify for SSDI instead of SSI, doesn't change much. So yeah, SSDI is interesting because it doesn't have all the rules that SSI has, and it goes along with Medicare, so it doesn't have all the rules that Medicaid has. However, if someone is getting services through DDA, those are still Medicaid funded, and so often people do still have to follow those asset rules if they're getting DDA services, such as a job coach or a group home.
I don't see any other questions that have come through.
Okay.
We know that just staying until the hour. So Lori Ferguson is great in Clark County. That's a great recommendation. Yeah. And then I know Peace, Tanya, if you're here. Oh, perfect. Tanya's, you're on it. You heard your ears burning. Peace has a lot of great information too. They have a whole list. So thank you, Tanya, for posting that. Well, while people are mustering up or thinking about other questions they might have for the last few minutes we have with you, Christy, before we take a break and switch to Peter, we just wanted to make a quick push and the case for the survey at the end of this training series. We send out a survey at the end when you close Zoom. So if you are willing and able, we would love your feedback to make sure that we have that input to carry on this series as it goes forward. And then the other thing I was going to say is we are going to ask, because we have a lot of people joining us tonight, and we just want to get a sense of who's joining for the first time or a returning person. So we're going to be launching a poll right at the break. So if you could check that out and make sure. Oh, thanks, Erin. Yeah, we'll capture that and then also in the poll as well. So if you have any other questions for Christy, feel free to put them in the chat at this time. And Erin, welcome. We are so glad you're here. Okay, well, oh, just in time. So from Michelle, how does the beneficiary need to be listed on things like retirement and life insurance?
Yeah, so that would depend on what you're wanting to do. So sometimes there are tax implications as to which kind of account you leave to which of your children, for example, if you have a child who has a trust and one who doesn't. So those are things that need to be sorted out and looked at carefully. But what you don't want to do is if someone does need to follow those asset rules, you don't want to just leave an account directly to that person. How do you name a trust? So if you have a trust, then if you have a trust in your will, then you would say the testamentary trust for and name the person. Under the will of, name the person. If you have a different kind of trust, you would want to name that trust exactly in the document. And I think it's good to get some legal advice or some advice from a CPA or a financial professional to make sure that you get those beneficiary designations done in the best way.
Great. Well, thank you, Christy, so much for your time and energy. Oh, if you'll do one more.
Yes.
There's one more. Do you need to file it directly with those companies also, like Fidelity or Northwest Mutual?
Yes, so whoever holds the account, that's where you need to have the beneficiary designation form. And you may have one already without kind of knowing it. And so it's good to anything like that to just make sure that your beneficiary designation forms say what you want them to say. It says we do, but it has the names, not the trust. Yeah, so if you have a trust, I would talk with those account holders and get that changed so that the trust is properly named. And if that's something you'd like me to help you with, I would be happy to.
Right. Well, Christy, thank you so much for your time and energy and for jumping in. This was such wonderful information. I imagine after people look at your materials, there will be more questions coming your way, and we'll also connect with you about the resources or the local suggestions to send out to families. So thank you for your time. We know that you're going to be jumping off to carry on with your spring evening. So we hope you enjoy the rest of your evening. And then if people have questions related to Christy's information, you can direct them to us, or you can direct them right to Christy through email after this event. So, and we are so pleased and delighted to welcome Peter Tassoni, who's going to be talking to us about the ABLE accounts. And thank you, Peter, for being here. We'll give you the floor, and we're happy to monitor the chat and help direct questions your way. So let us know how you like that information shared with you.
Awesome. Very similar to how Christy was doing it, so that would be great. I'm going to try to share my screen, so I want to make sure you guys can see it. So give me a thumbs up if you see the snowy landscape there. And so hopefully you're not seeing snow at this time of the year in your local area. I am Peter Tassoni. So Christy talked about the DD Endowment Trust Fund, one of the special needs trusts that she highlighted in her presentation. And I am the plan administrator for both the Washington State ABLE Plan and the DDETF, or the special needs trust there. And so maybe for next year transition fair, we can do a more in-depth, and I could give a presentation on both of those plans. And so it's a nice, side-by-side comparison. But I'm here to really talk about the Washington State ABLE. Christy did all the big work. I really narrowly focus on Washington State ABLE. For those of you, since you're down there on the Columbia River, Washington and Oregon are actually in partnership delivering the ABLE program. So Washington and Oregon's plans are nearly identical. We have all the same features, but the difference being in Oregon, I believe they have a state income tax deduction that if you live in Oregon and you pay Oregon state income tax and you have the Oregon ABLE program open, then you get that deduction for all the contributions you're making into that ABLE plan. Here in Washington State, of course, we don't have a state income tax, so we don't have any incentives that we can provide for folks. But for those of you guys that actually, there was a question earlier about guardianship, whether it's Washington and Oregon. But if you anticipate you're moving back and forth across the river, or you have parents that live in different states on different sides of the river, then Washington and Oregon combined, and we have what's called a ABLE for All plan, and that's our national plan. And so that way both parents could open up the one ABLE account for the beneficiary, and both parents could then be participating in the plan in the event that that's a separated household or a nuclear household in that case. But here, we're in Washington, so we'll talk about Washington ABLE plan. I got about 20 slides to go through. It shouldn't take me to 45 minutes. If you have questions as we go along, please put them in the chat, and I'll do the same thing like Christy did. I'll stop midway and try to answer them as we go. Well, I'll start with a definition of what ABLE is. So ABLE is the Stephen Beck Jr., and this is where the acronym comes in, Achieving a Better Life Experience, ABLE, act that President Obama signed in 2014. Washington State, we passed our state law in 2016. So the federal law allowed all states in the United States to provide an ABLE savings program. And then each state had to had to pass their own law in order to open up their program. And so then we launched in July of 2018. And we have nearly 2,000 enrollees, 2,000 accounts, and nearly $15 million in assets under management. So we've had a really great growth in the past couple of years of people taking on ABLE. And the reason why they want ABLE is the principal reason, what like Christy was explaining with the SSI in particular and other special needs or benefit programs, whether it's DDA or Social Security Administration or Developmental Disabilities Administration under DSHS here in Washington State, they have that $2,000 asset limitation. And so ABLE is a way to get money excluded from being counted. So once you get money into an ABLE account, that money no longer counts against that asset limitation. These are also tax advantaged savings accounts. And so that means you don't pay taxes on the earnings and you don't pay taxes when you take the money out as a withdrawal. And our definition of disability is really quite broad. It's much broader than developmental or intellectual disabilities that Christy was focusing on a little bit. So it's mental health, it's physical, it's developmental. There has never not quite been something like this vehicle for people that have challenges with mental health diagnoses and stuff. So the $15,000 a year, so you can contribute that $15,000 each and every year. It's linked to the IRS gift tax exemption. So a couple of years ago, that was $14,000. I think in 2016 or 2017, it went up to 15. As inflation and things continue along, the IRS will probably make another change in the next couple of years and will be up to $16,000 a year. So that's $15,000 each and every calendar year or tax year that you can put into an ABLE account. And that's the difference is that Christy didn't really get into between the special needs trust and ABLE is a special needs trust is literally an unlimited bucket that you can put as much money as is conceivable into the special needs trust. So if you have a daddy warbox in the family that wants to drop $1 million on your adult child, a special needs trust can do that. It's a bucket that can hold all that money, $100,000, $50,000, whatever the gift will be. ABLE, we're capped at that $15,000. So if grandma had $20,000 to give, then our system would reject it because you're over that $15,000 limit. So hopefully grandma and let's say it's Johnny are talking to one another and so that they figure out that, well, I got to do $15,000 now, and then I can put $5,000 again in January when we roll into the new year. So the $15,000 limit, it's a great game changer for ABLE nationwide, but that $15,000 limit it can be a challenge when you're thinking about wealth transfers through generations or what Christy was talking about with estate planning and having potentially a big inheritance at the end of mom and dad's lives or something. Here in Washington State, you have to be a resident of the state to enroll in Washington State ABLE program. You don't need to be a resident. You don't need to stay in Washington State once you open up the account. You can move out of state and still use your Washington State account. But at the time that you enroll, you need to be a Washington State resident. And the federal law requires your eligibility has to be that the disability occurred before age 26 and that you are considered disabled by the Social Security Administration's definition of disability. And the way you can figure that out pretty easily for the individual, the beneficiary, the account owner, that they are disabled if they are entitled to or eligible for SSI, the Supplemental Security Income, or SSDI, or the OASIs, which are some of the other Social Security benefits that go to like widows and dependents and stuff, very similar to the SSDI. Because essentially Social Security has already determined that individual meets the definition of disability and therefore they're entitled or they're eligible for these type of benefits. That second piece is you can self-certify and then have a physician or a psychiatrist, a medical doctor or a psychiatrist actually certify that the individual meets that definition and therefore is eligible for the ABLE account. You know, that age of onset 26. So that really means that you need to be born with something or you got a disabling condition pretty early in life. You can be 65 years old right now and enroll in an ABLE program or one of the plans. You just the disability had to occur before age 26. So you don't have to be younger than the disability had to occur before that age 26 happened for the beneficiary, which I will also call account owner because that's kind of terminology within the ABLE Act. So how does it work? So really think ABLE programs, you know, there's 50 states in the nation. We have 44 different states that have opened up an ABLE account. You're allowed one account nationwide. So the beneficiary can only have one account. And essentially all these programs, most of these programs are really online programs. So think online banking. It's our footprint is very digital. So you can actually fill out the application and upload the various forms that you need to all online. So it could take you 20 minutes. If you have all that information at your fingertips to get enrolled, then the minimum is $25 contribution to get your account started. And then it takes about a week to get everything verified and set up. And then after that week, once the money is good, you can turn around and pull that $25 back out of your account to spend on something that you need from your ABLE account. You can withdraw money multiple ways. You can go online, just like online banking, and you can make your withdrawal request and it gets processed online. You can actually call the call center and make a transfer request, and they can either move the money back to your bank account or they can send you a paper check. The third option is we have a prepaid debit card, and so you can actually make that transfer onto your debit card and then use that debit card. It's like a gift card. You can use that debit card out in community to make your expenditures to pay for services or items. And then again, that contribution limit is limited to $15,000 per year currently. There's a note at the bottom about SSI. So if the individual is collecting SSI, the first $100,000 is excluded. So if you get your balance grows to $105,000, then Medicaid or Social Security or any of those benefit programs, they will count that $5,000 as assets. So that first 100 of the 105 is excluded. But if you're on SSI or you're medical assistance, like then they're gonna count, that counts to 5. Now you're gonna spend down. If you're not on SSI, the limit is $500,000. So $500,000 for the Washington State ABLE program. However, I know you can do the math at $15,000 per year. We're talking decades before somebody gets up to that level. And this is the fun part of an ABLE account, is these 10 buckets really are broadly interpreted. And so these are throughout the life cycle of an individual, whether we're talking about a child, a young adult, a working adult, an older adult, a retired adult, almost all conceivable expenditures you would want to make from your ABLE account fit in these buckets, which is fantastic. So these are all life improvements, increasing independence of the individual, Basic living expenses can include groceries and household supplies, which for some folks that are familiar with SSI, those are normally things you cannot buy with a special needs trust, but you can with an ABLE. You can pay for your rent. You can pay whether it's Uber or Lyft or other transportation services, financial management, help, legal. You can use Christie's firm's services and pay for her services with the ABLE account. The other differentiating thing between a special needs trust and an ABLE account is funeral and burial. So with ABLE, you can pay for those things after the person passes out of their ABLE account for like their funeral, their wake, their memorial. Let's see, in Washington State, we have composting and cremation. So whatever the ceremony you want to do, you can pay that with your ABLE account after the fact. But with a special needs trust, you have to buy a prepaid program. So you have to prepay for the burial, the cemetery plot and stuff like that. You can't do it after the person passes. But ABLE's the wild, wild west. We're the new kid on the block. Very broadly interpreted. You can spend it on a lot of things. What you can't spend it on are the typical things that are illegal, gambling. You can't take cash out. You can go to the casino. You can pay for your dinner. You can go watch a show. You can pay for the comedian or the band. You just can't go gambling with that money. So, and you would have a special needs trust is you have the trust manager doing that work. So it would prevent the person from actually spending money on things that are not allowable. So we went over this a little bit, but the clarification is your SSI, if you ever got over your asset limitation of $100,000, you're not terminated. Your cash benefit is suspended until you get under that $100,000 and you get under that $2,000 resource. When you're in suspension, if you have that much money, there's no effect on your Medicaid benefits. So you still keep your Medicaid as is, even if it takes you 6 months to get down underneath that $2,000 limit. Now, there is another nuance here related to paying rent or housing. So with the ABLE program, if you're taking an expenditure out to check rent, to pay for your rent, you need to take it out in the same month that you pay the rent. So if you don't, what you don't want to do is take the money out at the end of February and pay your landlord on the 2nd of March, because the housing authority will count that money, that $600 that you had for rent, as a resource that was available to you because it went over the month into a new month, and that may adversely affect your subsidy for your housing. Although ABLE is a game changer for a lot of people, it's a very convenient and cheap way to protect those assets. A lot of benefits have a dual determination. So they're still counting your income and your assets. And so ABLE only protects those assets by making them non-countable. If you're earning income, if you have a job, if the beneficiary is working, has a royalty stream from the art that they sell, or earns commissions on the videos or the music that they create, that can still be counted as income and may affect the SSI cash benefit. So ABLE does a lot of things, but doesn't do everything. ABLE as a Roth IRA on steroids. And after I get done through the slides, we'll check in for if we've got questions in the chat box. But so a Roth IRA is a type of way that you can tax-free, tax advantage, that you can put money away for retirement. But if you look at the box on the right side, ABLE is at $15,000 per year, is 3 times as big as a Roth IRA. So that's why I say it's like on steroids. It's like there's a lot of money that you can put into an ABLE account, whether you're saving short term just to get to the next year, or if you're thinking long term, 20, 30 years from now, and truly have a retirement fund. they're really easy to get into. They're really easy to manage. We made our website and the user portal, the user interface. It's very accessible. It's configured in very simple language because we acknowledge that maybe a lot of our beneficiaries maybe are not they're not financial advisors themselves. So this might be new territory to them. So really easy to navigate, really understandable information about how to choose your investments, how to get your money out, how to put your money in, how if you want to set up an auto payment every month, if you want to do payroll deduction. There's a lot of tools on our website to make that very easy. And of course, the biggest advantage is that it doesn't affect benefits, particularly the SSI and Medicaid one. So Emily, I want to check in. Have we got any questions yet in the chat box?
Yeah, so there was one question. The question was just in regards to using the ABLE funds for vacation.
Yes, definitely. So that is one of the most popular things to do. So recreation, taking vacations, going on trips, going to the movies, Disneyland, Disney World, going to see relatives. Yes, all are permitted, eligible. That's a way to increase somebody's quality of life. My recommendation is you could go to your friends to the movie theater. My son's 13 and he has a developmental disability. And so I could see where I'd move like $20 or $30 onto his prepaid card. He can go to the movies with his buddies. He can use his card to buy his snacks, to pay for the movie. But the thing is, he can't buy everybody in the theater a snack or, a round of coffee at Starbucks or something like that. So it's not necessarily has to solely benefit the account owner or the beneficiary, but it has to be reasonable. And so again, don't buy the whole bar, a round of drinks, whether it's Starbucks or a tea shop. But definitely, yes, use it for on vacations. You can help pay the care provider that needs to go on the vacation with the individual. That's doable too. You can do supported work. If you need work clothes or uniform, stuff like that, you can use your ABLE funds to help keep somebody in an employment situation or even get them into an employment situation. So good question. Vacations. I always like to read about people having good vacations. And this is what I was talking about, optional debit card, a little bit more details. It is, we have, close to 2,000 enrollees at this point. We have a little over 300 folks that are actually using the prepaid card. You can preload it up to whatever amount is in your ABLE account. So, if you have $5,000, you can put $5,000 on the card. Reason the governing board chose a preloaded card is just we acknowledge that some of our kids and certainly our adult children are more vulnerable or can be influenced by peer pressure and stuff like that. And so this is a Visa debit card. So if it gets lost or stolen or it's being fraudulently used, you can call up and they can stop the use of the card. And at most, if you don't do it fast enough, report it fast enough, the most that you'd be out is the money that was actually card. Unlike a true debit card where they can actually use it to tank everything that you have in your ABLE account, you can't do that with our card. So that's a security provision that we put in, knowing, I don't want to be the guy that's looking over all our kids' shoulders and how they're spending their money, but it is a safety provision that we put in on this card so that they don't have to be, so they're not unduly influenced and lose all the assets they have in their ABLE card. We do allow, I'll talk a little bit more about authorized legal representative, but that is essentially a person with a power of attorney or a guardian, or as what Christy was talking in January 2022, conservator can also have a card so that the beneficiary can have their card. And like my son, I'll put $20 on his card, but I'm dad. And even though he's 19 years old, I'm still running his account and I've got $2,000 on my card. And that's what I'm going to use to pay for medical co-pays. That's what I'm going to use to pay for his rent. That's what I'm going to go out grocery shopping with him, and I'm going to use that card to pay for those type of expenses. So his card, small amount, he can use for his recreation, provides me with a little more peace of mind because I've got the second card with the bigger amount of money that's making the bigger transactions. Another advantage, Christy talked about the guardianship and the every year or every 3 years going back to the courts with an accounting of how the money's been spent. Well, with our online system, things are tracked online, and with the prepaid card, even those transactions are tracked online. So you can always go back and get that history if you need to, make your filings with the court, or if you just need to let your adult child, the person that you're running the account for, help them understand where the money's going and how you're spending it and stuff. So really nice tool sets in there. And our prepaid card provider is TrueLink. That vendor, their whole mission is helping people with disabilities with financial vehicles. And so their user portals are really amazing in that we have a person that's fighting addiction issues, and they're trying to stop smoking. And so you can actually go into your prepaid card and you can eliminate or block vendors that sell tobacco products, and at either the vendor level or at the merchandise level. So when my child is having a bad day and he's 19 years old and he goes into the Safeway or the 7-Eleven to buy a pack of smokes and a gallon of milk, well, the cashier will say, well, I can't put the cigarettes on your credit card, your prepaid card. You need to pay it with something else. And so it's for those folks that have challenges, that might be a nice tool for them to use. I just think, TrueLink is a great vendor. Appreciate the work that they do supporting the plan there. So something, Christy talked about third-party trusts in particular, mom and dad's money. Well, aunt and uncles, they can also contribute because it's not the beneficiary's money that can be all lumped into the contribution, but that's kind of word of mouth. On Able, the platform itself, you can literally run a GoFundMe campaign. So we do e-gifting. And so you can actually set up a program, you set up your page, you can send it out to your friends, you can put it on the social media, email them, and then they can come in and make contributions either from their bank accounts. They could use debit cards or credit cards, and that gets all put into the individual's Able account. Now that $15,000 limit still applies. So if one of your friends happens to be Daddy Warbucks from Little Orphan Annie's fame, you got to let them know that can't accept $1 million, but $5,000 would be great. You can run this for vacations, a GoFundMe style campaign to take a vacation. Maybe you have a Special Olympics so they need money to travel to the regional games or something, or maybe they're just saving up for the latest DVD or some CD or something like that, and so they can give contribution a thing. I mean, it's really cool. Now, something that Christy didn't really spend a lot of time on, but she talked about that first party trust. And so Able accounts are essentially a first party trust. So it doesn't matter where the money came from. So mom, dad, I'm about to get a bloodhound to come into the room, so there might be some noise with the dogs and stuff. So bear with me. So it's first party, it's considered first party money, regardless of who originally gave the money. It's all first party money. And we'll talk a little bit about that in a couple more slides. But the investment options that we have here in Washington State, also in Oregon, it's the same 4 options. So we have these 3 different market options between stocks and bonds. And we use the 8 different, okay, right number of fingers up, 8 different mutual funds are just in different ratios and proportions to give the kind of return and risk ratios of conservative, moderate, or aggressive. The fourth account that's not listed here is the FDIC insured savings account. It's just like a passport savings account you have at a financial institution. It's insured against loss in case the bank goes bankrupt, so you don't lose your money. So you have those four options, and you can put your money, each contribution you can put into the different funds as the person wants. But that's the person, the account owners, they choose how to put the money in. It's not these third-party contributors. This is probably one of the better enticing things about ABLE is it's really cheap. So no fee to enroll, $25 initial contributions, and then at least $10 thereafter. And it could be lump sums. It could be very regular, like you can make monthly contributions. You want very irregular, that maybe you'll deposit $5,000 once every 3 years and then slowly use up that money or save up that money for the future. Either way, we do charge $35 maintenance fee. Again, the $1.25 per month for the debit card. Our investment fees are really low, and that's 0.30. So that's a percentage point with a decimal in front of it. So that's 30 basis points to 38 basis points for the investment fees. And that's what Vanguard charges us to invest the money. Miscellaneous fees are things like mailing, postage. So if you need to have your statements mailed to you, or if you need to have a paper check mailed to you, then there are some fees. Or if you check your contribution check bounces, we'll charge fees for that. So Emily, I saw you flash on. Does that mean there's a chat room question or two?
Yep, there's some questions that have rolled in, Peter. So people have, let's see, let me back up a few. So what happens to funds in either an ABLE account when the person with a disability passes away?
Yeah, and that's great. So that's why I want to preface that with first party money. So what Christy was saying is that money gets paid back to Medicaid in the Medicaid recovery. So ABLE's the same way. So that's determined to be first party money. So when the person passes, Medicaid is going to get their chunk, but they are second in line. The tiered system is you get 60 to 90 days to pay off any outstanding ABLE expenditures, those qualified disability expenditures, which could include the funeral, the burial, or the memorial, whatever wake ceremony, and anything that was in the works. Say they were having a van modified so they could have a wheelchair ramp roll into it while they died before that work was completed. You can still use the ABLE funds to pay off that work to date and to finish the van's modification if need be. Then the state's in line number 2. And so then they would do their Medicaid lien, they would recover whatever DDA waiver services, in my case, with a small child, a younger child, but if they were in a nursing home or have other services going on through their adult years, their Medicaid will get their chunk back. If there's money left over after that, then it gets dispersed however the person who had a will had designated, because now the ABLE funds is considered part of the estate. If they don't have a will, then it goes through the probate or the court system. So just to highlight what Christy was saying, a will is still important, even if the person has a disability. So yes, Medicaid payback, the clawback, as some people like to call it. Emily, was there another?
There's a couple other ones. Yeah, so people asked if you could recommend a financial advisor in Clark County who would be knowledgeable about having a family member with special needs that you'd want to care for long term.
I don't. I would probably go at Peace Northwest. They seem to be pretty well integrated. Across the river in the Portland is Pelagio, and Connor Conovan runs a special needs planning tax advisory firm. And so if you're on the Oregon side, he's a good contact. I'm sure they have stuff in Washington State. I just don't know off the top of my head. And his site also has webinars and talks about some of the highlights of estate planning and financial advisement related to insurance and medical insurance and life insurance and stuff like that, and owning a home and stuff like that. So I'm sure there's somebody in Clark County. I just don't know.
Perfect. And there's a couple more questions. I just wanted to let the interpreters know I'm going to switch you because we're at a good pausing moment. So yeah, take a breath, have a sip of water, Peter. It's so great to hear from you. Okay, so next question. Would you recommend an ABLE account over a traditional account in your child's name?
Well, they're very complementary. So a lot of times I think people will choose all three. So there is a situation where it's mom and dad's money. You want that third party trust. So I get to determine where the money goes should my son pass prematurely. And that means no Medicaid recovery. If my son is working, he might want a first party special needs trust to put his earnings into. And then we can transfer money from those special needs trust over to the ABLE account. And then my son could use that prepaid card and be out amongst community just like everybody else with his own credit card, debit card. And there's some advantages and disadvantages to each. So the biggest ones, with ABLE, I can pay for rent, I can pay for groceries, and there's no detriment, no decrease in his SSI cash payment. So, I could see where you might want all two or three. ABLE's the spending side, but the lump sum, the bigger bucket is the special needs trust, and you can move money down to ABLE as you need.
Great. And just to echo your comment, Peter, about local resources, Tanya from Peace, who is with us tonight, put the contact for Peace in the chat. So if people are looking for that as well. And then John echoed that, let's see, Connor Kavanagh is great. From Pelagio.
Awesome.
Yep. And then let's see here. There's one other question. Are there fees for using the ATM debit card other than the monthly fee?
So with our card, you can't use it in ATM. So no fees because you can't use it. If you really needed to get cash, you could either have the money transferred to your bank account and then go into a financial institution and either write a check or take the money out from the teller there at the financial institution. But it's more difficult to track your expenses and your receipts if you're using cash. So that's the advantage to be using either checks from your checking account or use the prepaid card because you get that transactional history there.
And Peter, is it good to keep the questions rolling? Does that work for you?
If you got them, just a few more slides, maybe two that are big, but everything else is quick after that.
Okay, I'll shoot these two and then we'll get back to your slides.
Excellent.
So can money from a third party trust be moved to an ABLE account and vice versa? So
yes, it can be moved from the third party trust into an ABLE account, but not the reverse. Because remember, we're taking third party money, and then once it gets to the ABLE, it's now considered first party money. You cannot move first party back up to that third party trust. And if you do, you break the walls of the trust. The trust is no longer a trust, so you cannot have that happen. And that's why various trust managers won't let that happen. And that's where you need to pick your trustee well. That's what Christy was talking about, so that they don't allow something like that to happen, because you do not want that trust, that shell, to be broken by something like that. So always think of it as a one-way trip. You're sending it down to ABLE.
Okay, great. And to clarify, for first party trust, does that state only receive money from it when your child passes, if they are working and not just on SSI? Asking, oh, sorry, there's just a follow-up part. Asking because at this time they are not sure my son will be able to find a job with his skill set.
Right. So a first party trust is will go through Medicaid recovery. So if there's any assets in there at the time that the person passes, that is a recoverable for Medicaid clawback. So it doesn't matter how the money got in there, whether they were working, whether they received a settlement, whether they received an inheritance in their name. First party trusts are always a recoverable Medicaid clawback.
Great,
And so,
thank you. And
yeah, tough to know if he's going to work or not, or the child's going to work or not. But you know, if the money showed up in their name, you have to put it somewhere. It either goes into a first party special needs trust or it goes into an ABLE account. Otherwise, those assets get counted for against your SSI.
yeah, and just a little plug, next month we're doing the value of employment, a panel that highlights all different types of jobs for different skill sets and where people are coming from. So if you want more information on that, we're happy to send that along too. So thank you, Peter, and thanks for the question. And then one more before you jump back to your slides. I think it'll be a quick one. You mentioned rent, but can you use the ABLE money to purchase a condo or a home?
Yep. So certainly, so I would anticipate you probably make a down payment or a deposit, and then you can make recurring mortgage payments. But yes, definitely, yes. So going back to the slide, since Emily was talking a little bit about work, so you have the standard contribution limit of $15,000 per year, but there's also a provision for the next 3 years is able to work. So if the beneficiary, if the account owner is actually working, if they're earning some type of income, they can contribute an additional $12,760 or how much their wages are until it gets up to that $12,760. So that's 15 and 12, almost $13,000. So now you've got a super duper ABLE account on steroids compared to a Roth IRA. $27,000, $28,000 is possible, but there is that nuance that your employer cannot be making contributions already into a defined contribution plan like a 401k. So as long as, you know, certainly if someone's self-employed and able to work is an additional way to get money in. You can do payroll deduction through your employer. We also do authorized legal representative, a guardian, or a power of attorney. You can also have rep payee, organizational rep payees that provide that type of service, you know, handling the financial affairs of the individual. They can get documented in our system, and then they can be an ALR for the individual in the event that, you know, maybe they don't have family members to help them run their account. And the IRS surprised us late last year. They dropped the final rules. You know, ABLE's only been open for about 6 years. College savings plans have been around since the mid 90s, and they are still operating under the IRS draft rules. So they've got, you know, 30 years in, and we got surprised. So IRS makes some subtle changes to the rules, and it's going to take us about a year to roll those out. For the most part, it made the ABLE accounts stronger, with the advantage of more people like rep payees being able to help an individual to run their account. And this is a nice segue to what Emily was talking about for next transition fairs workshop. So SSI, there are great programs, and ABLE can work with a person that's wanting to get back to work and work through the various programs that you'll learn about at the next session. And so there are two that work together pretty well. And so here's just the fast, how do you get set up? So I've convinced you that this is a good idea, or you just know this is a good idea. So you can go in and set up an ABLE account for yourself, or if you are a parent of a minor, this is the type of information you need to have. If you're setting it up for somebody else, then of course you need to have their information, and you need to have that similar information for yourself to set up both sides. So my son's only 13, so this is what I would need to get set up. And I've been told it can take you anywhere from 15 to 20 minutes to get set up online. If you want to do it the paper route, you can go on to the website and download the forms and then fill them out by hand, and you can mail them in. And so it may take you now 2 or 3 weeks to actually get set up, just with the mailing time and the processing time of a paper document. But it's really quick and easy. We have put various videos up there on the website to help folks be more efficient and effective in using their accounts, from enrolling to how to make a gift page, to making contributions, reoccurring contributions, one-time contributions, to taking your withdrawals. These videos are about 6 minutes long, so they're really quick and easy. We're just starting a new video blog series where I will be talking for about 2 minutes, and we'll try to do one about once every month to try to hit on key points that our beneficiaries and account owners may want more information on, or they're struggling with. And so we want to bring clarification on either the program or the user interface so that they are more productive in using their account. Washington State, before we launched, we went through a process of changing various state agencies' rules so that they would exempt ABLE from their eligibility determination processes. So in Washington State, the Healthcare Authority, HCA, our Medicaid program is called Apple Health. So ABLE is exempted from that program. DSHS, SNAP, which is the food benefits. TANF is, in the old days, called welfare. ABLE assets are not counted in those programs, so they don't jeopardize those benefits. Social Security Administration, within their POMS, which is their operating manual that their caseworkers use, has that citation, that page that also has ABLE exempt, and tells the caseworkers that, don't count ABLE. And even with HUD, which is a national program that the state passes money through to local housing authorities, they've also have the policy that ABLE is exempt and stuff. So if you have problems with your beneficiary, your account owner, as a caseworker, as a advocate for your person, you can go right into these rules and pull them up and use that against the caseworker and say, look, even this is exempt. Even your own agency is telling you this is exempt. So just quickly to recap, we're online. It's really easy to get set up. Your disability onset had to be before age 26. Washington resident to get set up, $15,000 per year in contributions. Anybody can contribute. And for those that are on SSI, the first $100,000 is exempted. Otherwise, our limit is $500,000, which will take folks decades to get there. This is what I mentioned. The DD endowment is something that Christy mentioned, but it is a special needs trust program with both third party and first party trusts. And we say they're very complementary. And I actually give presentations on both in a compare and contrast fashion. ABLE accounts are essentially where the population is. So here's the darker colors of this heat map are essentially along the I-5 corridor, with Clark County, one of our stronger enrollment counties. So, here we are, we're like 1,960 accounts, I think we have, and just shy of $15 million. So by the end of this month, by the end of March, we should be over $2,015 million in assets. So fast growing program. You can find information about ABLE on a whole bunch of different channels, from the website to Facebook to Twitter to our YouTube channel. That's where you'll be seeing video blogs starring me, Peter, coming out shortly in the next couple of months, talking about some various topics, ABLE-centric. So that's all I have for you today. I was surprised, Emily. I did go 45 minutes.
Peter, if you'd be willing to answer one more question. I realize I missed a second part of a question that came up again. So I want to make sure I capture this because someone said, hold on. I also have that question. And thank you, Peter, for your time. I know it's been a long day, so it was really great to hear from you this evening. Okay, so maybe it's wise, this is the question. So maybe it's wise to keep more money in the third-party trust and move smaller amounts to the able as needed and avoid a big loss with Medicaid clawback upon death.
Yep, that's pretty savvy. We do have parents that have already figured that out using our program. So the DD endowment, Christy mentioned it. We have 2,700 active accounts and nearly $100 million in assets under management. And so even some of the parents that have small accounts, $20,000 compared to some that have like $100,000, it's really easy to just winnow that money over the able in small increments. And so if the beneficiary maybe has some serious health consequences or challenges, so you don't know, you don't feel confident maybe they might pass in the very immediate future, or you're like me when I was young, had a very risky lifestyle, that could be very prudent thing to do. Keep the most of the money in the third-party trust, only move it to able as you need it, or as the person is able to use their funds. Because the able account, the account owner is the owner, similar to what Christy was saying. Even if you have a power of attorney, they still can run their account. You need to get that ALR in place, and guardianship is the strongest in order to run their account for them. But yes, that would be a prudent, conservative thing to do.
Great. Well, thank you for answering that, and thanks for your patience in the chat for the loop back on that question. Peter, thank you so much for your time and energy. You're getting the thank yous in the chat as well. This session has been recorded, and so you can access this in both English and Spanish. Not tonight, but stay tuned. Probably within the next 2 weeks. So if you don't see that on our website, feel free to always reach out to myself, Emily, at GoWise, or my wonderful colleague, Beth McKinney, who is Beth at GoWise.org. And then the other thing I was going to say is, please, if you have an extra 2 moments, we would greatly appreciate any feedback you want to put in the Survey Monkey that's posted in the chat. It's really helpful for us to think about how to keep going with this series and how to improve this series, or carry on the great presenters that we've brought to this series. So we greatly appreciate you taking the time to do that. And we hope everyone has a wonderful evening. We'll stay on for just a minute until we get to the hour. And thank you to all of our interpreters who are here tonight, making this possible for our families to access this information. See you soon, Peter.
All right. Ciao,
Take care.
everyone, and the rest.